Greetings. My name is Kyle Janczewski, and I will be presenting to you today about search procedures in the school setting. Let's get started. The learning objectives for the presentation are as follows. By the end, participants will be able to become familiar with the relevant search laws, policies, and regulations in Illinois schools, familiarize themselves with the relevant search law cases, their outcomes, and the impacts that they had on conducting searches in schools today. They will be able to distinguish between probable cause and reasonable suspicion, identify how schools can notify parents and students of their privacy rights when a search is conducted or about to be conducted, compare and contrast the various types of search procedures, define the role of school resource officers, also known as SROs, and law enforcement officials when a search is conducted, and lastly, they will apply what they've learned to a potential real-life search procedure scenario. First, we'll talk about relevant laws, policies, and regulations relating to school searches. The Fourth Amendment of the United States Constitution specifically prohibits unlawful search and seizure, and the Constitution of the State of Illinois, if you were to kind of look both of them up, the United States Constitution, Fourth Amendment, and the Article 1, Section 6 of the Constitution of the State of Illinois, they are nearly identical. They pretty much mirror each other. Basically saying that searches and seizures are not permissible unless a warrant with probable cause and evidence is obtained, that people have privacy to their rights and their belongings. With that said, the next three, 105 ILCS 510.22.6E, 105 ILCS 510.20.14A, and 105 ILCS 510.22.10A, and 105 ILCS 534.18.12 all deal with some form of searches. The first one is specifically outline school searches. The second one discusses Parent-Teacher Advisory Committee basically recommending that schools and parents collaborate and work together to come up with policies and procedures. Of course, one of those policies and procedures could relate to search policies. And then the last one would include the inspection for drugs. The last two, the Right to Privacy in the School Setting Act, prohibits school administrators from asking parents or students what their login information for social media sites would be, so possibly their email or their password. Administrators, school officials cannot inquire about that information. Lastly, the Joint Committee on Administrative Rules, JCAR, which was created by the General Assembly in 1977, it highlights four procedures for search. The first one, however, would be the most important. It states this would be A, the superintendent or designee of a state school has the authority to approve the search of any student's person, locker, room, or property when the superintendent/designee has a reasonable belief that the student has alcohol, drugs, a weapon, stolen goods, or any other item prohibited by the state school rules. Any search of person must be made by staff of the same gender as the student being searched, with another staff person present as a witness. So these are the relevant search laws, policies, and regulations for searching in schools and Illinois. As far as relevant search cases, there are 5 essential cases for school search policies and procedures. The landmark case of New Jersey versus TLO, this case initiated the difference between probable cause and reasonable suspicion for school officials to search students. Essentially, what they decided in this ruling was that the level of suspicion needed to conduct a search should be lower than that of probable cause, basically saying that school officials act on reasonable suspicion and not probable cause as police officers do. I'll cover that in greater detail later. Next, in Burnham v. West in 1987, the court determined that even if the odor or the smell of drugs is noticed in the hallway of school, the school does not have enough evidence or, again, reasonable suspicion to search all students' personal belongings. So they covered the fact that they cannot be what's called a blanket search. In Safford Unified School District v. Reading, the court decided that carrying out a strip search on a student meets much stricter requirements than other searches, due mainly because a strip search is incredibly intrusive when it comes to student privacy. In New Jersey v. Best, the court ruled that reasonable suspicion was sufficient enough to search a student car parked on school grounds. Depending on the information that is provided, school officials can search vehicles parked on school grounds. And then lastly, in GC versus Owensboro Public Schools, the court ruled that content on a cell phone requires school officials to essentially create a specific factual basis for searching the phone. They need a reason to do so. Many other cases involve student search procedures here, but these are the ones that are most influential to date. This slide identifies the differences between probable cause and reasonable suspicion as it relates to search procedures. Probable cause is required for police or other law enforcement officials. Generally, but not in all circumstances, law enforcement officials must obtain a warrant based on probable cause that a judge has issued. Under the probable cause standard, a governmental official must have reasonable grounds of suspicion supported by sufficient evidence to cause the official to believe that the suspected individual is guilty of the alleged offense and that the search will produce evidence of the crime that was committed, is being committed, or will be committed. If the probable cause standard is violated or ignored, government officials would be violating the Fourth Amendment as previously covered, and then, of course, would be subject to civil or criminal charges depending on if the person wanted to press charges. The most important resolution or fix really for the person who is illegally searched is what's called the exclusionary rule, and the exclusionary rule declares that evidence that was found or collected during a search is inadmissible because it was found illegally. In reasonable suspicion, this is what we refer to mostly for school searches. Reasonable suspicion you'll see peppered throughout the presentation. Because of the results of New Jersey versus TLO in 1985, which I've previously covered, the Supreme Court ruling, of course, that even public school officials are indeed state agents, they have a significant interest in maintaining discipline and safety in a school setting. They decided that because this is necessary, instead of the probable cause standard, they should ease the expectation and lean towards what's called reasonable suspicion. Okay. The Supreme Court came up with two tests to determine if a search is considered reasonable. First, is the search justified at its inception? In other words, did reasonable grounds exist to suspect the search would produce evidence that a school policy or law was broken by the individual being searched? Second, is the scope of the search reasonable? Again, in other words, the type of search conducted is related to the objective of the search and not overly intrusive based on the seriousness of the suspected violation and even the age and gender of the student. The goal of a search is to reestablish and maintain student safety throughout the school. That's why school officials conduct a search. Next, we have the notifying students and parents of their privacy rights. Of utmost importance would be including search procedures in the Code of Student Conduct and Parent Handbook. So review this information along with everything else in the parent handbook, especially the most serious problems or issues facing the school. But review this with parents either before school starts or during open house within the first couple weeks. Review it with students. The teachers can review it with students the first week of school, go over the information, and then there should be a tear out portion of the student handbook where students and parents can sign it, basically stating that they have read and understand the policies and procedures. Parent-teacher advisory committee. These should be formed. Parents and teachers and administrators should be collaborating together to take a look back on previous handbooks and make necessary changes or removal of things as necessary. Again, highlighting searching procedures and policies to accommodate any changes that they think need to be made. Search procedures have a 3-step process. So when it comes to searching prior to initiating the search, during the search procedures, and then search results and follow-ups. So prior to initiating, the administrator would want to gather a witness, whether it be an SRO, a police officer, or another teacher. They would want to take the student out of class and then require that all other classes stay in their classroom to ensure student privacy. Before initiating the search, the administrator might want to give the child a chance to do a self-search, kind of just admit whether they have anything or not. Then we get to step number 2. Before step number 2, we want to communicate with the student why we are conducting the search, explaining that student safety, school safety is at the forefront of this search. Step number 2 would occur if the student says that they don't have anything. They might empty their own pockets. They might hand over their book bag. At that point, step two is basically the search itself. Again, want to have a witness there to see what is happening, to see if anything is found or not found. Step number three, after the search has been conducted, it depends on what was found, really depends on what happens. If drugs or a weapon are found, drugs might be just turned over to the police, but then disciplinary action is usually passed down from the district office, likely the superintendent. If nothing is found on the student, then really nothing would happen. It would just be, thank you for allowing me to do the search. Communication is key. Lastly, as far as the conclusion of the search, it is critical for school administrators to contact parents and guardians and inform them of the search, whether it be before or after, really just depends. This is to help guarantee that parents are aware of the search, why it was conducted, and then the results. It would be important to remind parents that we want student safety to be achieved at all times, and that's why we conducted the search. The next couple slides will discuss search procedures, including lockers and various personal belongings. For lockers first, this is an extremely low expectation of privacy, mainly because they are school-owned, they're school property. So the concept of joint control, that means that students can use the lockers, but they are still school property, so the school can use can have reasonable suspicion to search them, but it is not always required or necessary. Again, all about the fact that the school owns these lockers. And this goes for other school-owned properties such as tablets, computers, and sometimes even cell phones if they are connected to the school servers. Some schools in certain states, when it comes to locker searches, mention that a student will be notified prior to a locker search. Other states say that there's no expectation of privacy in school-issued property. So it really just depends on the student code that is outlined in the handbook. Now we'll go to personal belongings, including backpacks, purses, wallets, gym bags, or even other student property. Cell phone car searching policies we'll discuss next. In contrast to school-owned lockers, a student's personal belongings are privately owned, and therefore they have a greater expectation of privacy for searching them. Still, however, is the reasonable suspicion standard, and that school officials must have what is referred to as individualized suspicion. This means that school officials, administrators can't conduct blanket searches for the entire school or even a group of students. They must have individualized suspicion, searching one student or two students that they have suspicion of finding something. As with most situations, it depends on the circumstances, and each situation varies case by case. Personal belongings next would be the student cars and cell phones. As far as student cars, if they are parked on campus and the school official can determine the reasonable suspicion standard that we've been discussing, that vehicle can be searched. There have been other cases where cars could not be searched if they are off campus or it's a part of the school that the school doesn't own. So let's say the truck was parked across the street. If it's a public road and not owned by the school might not be able to search it. Really, again, just depends on case by case in order to determine the safety of the school, if it was in danger or even student safety was in danger. Student cell phones, they're a hot topic. We talked about them in class already, but when it comes to cell phones, when we talk about cell phones, the GC versus Owensboro Public School 2013 case, again, the reasonable suspicion standard. However, it just like others, it varies case by case. When it comes to searching a student phone, as we discussed, it's never a good idea to search a student cell phone unless there's suspicion or evidence that the safety of the school is in danger or that the school day has been disrupted by the use of a cell phone. But again, safe bet would be to not search a cell phone, especially for teachers. School administrators, it's a different line, but teachers turn the phone over to a school official, school administrator, to conduct that search of the cell phone. Next up, we have the search procedures for outer clothes and strip searches. Student pockets and shoes we've already covered. Those are under the reasonable suspicion standard. So as long as the school official can determine reasonable suspicion, the student pockets and shoes can be searched. Strip searches are an entirely different beast. When it comes to strip searches, because they are extremely intrusive and they really invade the personal privacy of a person, we must have a lot more reasonable suspicion, almost to the point where it might become probable cause. So in this scenario, in this case, it would be advised to avoid strip searches if possible. Use them as a last case scenario. Next, we have the concept of specially trained dogs searching in the school. The U.S. Supreme Court has identified that using drug dogs or other various sniffing dogs does not constitute a search simply because the airspace around the object is reasonable suspicion. It doesn't hold the same privacy standard as the object itself. For the most part, we have judicial support for the use of dogs has been limited however, to just the sniffing of certain objects. So the questions that you see, is reasonable suspicion required to use drug dogs, or does the dog itself create the reasonable suspicion? It really depends on the circumstances. Fifth Circuit Court held that reasonable suspicion is required for a further search of a locker or car, just in case, of course, if they didn't find anything in the locker, but then search the vehicle with the dog. They would need reasonable suspicion before searching the car. Supreme Court has ruled that drug dogs could establish reasonable suspicion, but it really depends on the invasiveness of the search and where or what the dog was alerted to. So when it comes to drug dogs, each case could be different. In order to apply the use of drug dogs, it is really instituted by the district office, but mainly the superintendent. They'll call law enforcement to bring in the drug dogs. The search will be conducted. It would be important for the school, the administrator, to communicate with all involved, sometimes a phone call to all stakeholders or an alert to go out. Once the search has been concluded, the law enforcement will notify the superintendent, the district office, of the findings. And then as far as disciplinary action is concerned, it really just depends on what was found. Sometimes the superintendent may require or may suggest 10 days of suspension if something serious was found, and the student would be facing a board hearing for possible expulsion. Again, really depends on the items that were found. Last up for search procedures is the concept of metal detectors. Courts have ruled that schools can use metal detectors simply because they're extremely minimally invasive and intrusive, and it's really just the general scanning of items. Now, if the metal detector alerts to a personal belonging like a backpack or purse, it can create reasonable suspicion for that item to be searched. Again, allowing the school official to do the searching. Metal detectors, as much as we may think a lot of schools have them, they're actually, schools that have metal detectors, they're actually the exception and not necessarily the rule. So metal detectors are not extremely common in schools. It is important to note as well that for metal detectors, they do not guarantee safety. It's really only as good as a well-trained staff and student and knowing the surroundings. So metal detectors, while they can be an additional element of safety, they're not the hardcore answer to school and student safety. This slide is a simple graph that we can find in our textbooks, and it really just portrays the concept that as the search to be conducted gets more intrusive, the level of suspicion required by the person doing the searching, usually the school official administrator, it must be higher. So you can see less invasive searches like lockers, metal detectors, they require low level of suspicion, but then we get to strip searches. Sometimes, of course, we can even include pockets in there. As the search gets more intrusive, then more suspicion and even sometimes evidence is necessary to justify the search. Last, we'll talk about school resource officers, also known as SROs, and law enforcement officials and their role in conducting searches. Now, first let's define what a school official is. These include teachers, administrators like principals, assistant principals, etc., school presidents, and district office personnel, such as attorneys, accountants, human resources professionals, etc. Nowhere in that definition, however, does it include SROs or law enforcement officials. So, with that in mind, that means that SROs and law enforcement officials cannot conduct searches, correct? Not necessarily. It really all depends on the agreements that the private security company or law enforcement agency has in place with the school. So when we talk about, let me give you a scenario. So if law enforcement officials or SROs conduct a search that has been requested by, let's say, the principal of a school, courts will usually apply the reasonable suspicion standard to the search. However, in the case of, let's say, State of New Hampshire versus Hertzler, law enforcement officials who search based on information that they have obtained from the school resource officer, those law enforcement officials would be closer to the probable cause standard because the SRO is not a, quote, school official. In the case of Florida versus DS, just because a law enforcement official, so like a police officer, is present for a search, that does not necessarily mean that probable cause is needed. All right, if they're witnessing the search, it's still reasonable suspicion. Lastly, we have the interagency agreements. A lot of schools have these interagency agreements in place with SROs and law enforcement officials to help maintain a safe school environment. A comprehensive interagency agreement provides past school incidents and suggestions on how to handle them appropriately and, more importantly, legally. Now, let's apply what you've learned about search procedures to a potential school situation. So it's a bomb threat scenario. Let's say that you are the principal of the local elementary school. You've received a suspicious phone call around 9:30 a.m. The caller states that one of the students entering your elementary school has a bomb in their backpack. The elementary school serves K through 6 students. The elementary building is also attached to the middle school. So they're connected. The elementary and middle school are connected together, and the middle school serves students in 7th through 8th grades. The question: what would you do to ensure student, staff, and even sometimes community member safety? How would you conduct a search to guarantee that you adhere to all individual laws and regulations while still maintaining a high level of safety and security? Would you incorporate assistance from local police officers? Why or why not?